Ms. Ferrante, who joins me at the table.
All right. We are here for a probable cause conference. It does not look like there's a resolution. Is that correct?
Correct, Your Honor. But there is a waiver of the 14-day rule that people would ask for an adjournment in this to give more time to exchange discovery and hopefully come together in a resolution.
How is discovery coming together in this case? You still have you received anything yet?
There are drafts that I reviewed, but MSP needs to review those before I can hand them out. So I would say it could be a week before we're final.
So with the waiver of the 21 days, that puts us at the 27th. Do you think that's sufficient time?
The 27th
January.
I would ask that
Would you oppose that, but if you could address it ongoing forward, I would appreciate it.
Mr. Hartel, any objection to addressing that? I'm sorry, Mr. Carnes.
no objection to defense raising the issue, Your Honor.
All right, so we will move this then to the 3rd of February. Mr. Hartel.
Yes, thank you, Your Honor. I did regroup with my client before coming in today. She does want me to address the bond situation. If the court was willing to consider lowering it, preferably to a personal recognizance. We do realize this is a serious case, serious allegations, but she's advised me that she does have family who is willing to put her up in a hotel room and pay for that, or an apartment maybe. Yeah. And that way she would have a firm residence. So if the court did still want to GPS tether her, she could do that. I just would hate to see her waiting in jail while this is continuing to end. She does want to get all the discovery as well. For all we know, it might have exonerating stuff and it won't know until we see it. But at the same time, I would hate to see my client lodged pending that. Our office, social worker, the public defender's office, Mr. Brian Henniger, will gladly help her. Well, he can't in all the ways that he can. But her, I believe, mother, was it?
Yeah.
All right. Her mother is more than willing to help her initially get that. And if it is a GPS tether to an address, then obviously that would overcome some of the court's public safety concerns, hopefully. Thank you.
Mr. Carnes.
Thank you, Your Honor. I think bond is appropriate where it's currently set. These are serious allegations lying during a home invasion murder investigation. And the defendant has extensive criminal history from Kentucky and appears to have resided in Kentucky. So I think the seriousness of the offense and the defendant's lack of ties to this community are both concerning. I would ask court to keep bond where it's set. Thank you.
All right, when looking at the bond factors in 6.106, the court is to consider the prior criminal record. So let's run through that. In 06, there was a robbery second, possession of forged instrument, theft, receipt of a stolen credit card or debit card, possession of burglary tools, theft, a receipt of a stolen credit or debit card. Then in another case, there was another robbery second, possession of cocaine, possession of burglar tools, theft, or receipt of a stolen credit or debit card, possession of a forged instrument second. In 6, there was a theft by unlawful taking, and in 17, a shoplifting under 500. Record of appearance or failed to appear. The praxis does not indicate that she has any failed to appears. A flight to avoid prosecution, there's nothing regarding that. History of substance abuse or addiction. The only thing the court has in that regard is back in 06, 20 years ago, possession of cocaine. Mental condition, character, reputation for dangerousness. The court has nothing regarding that other than the criminal history and the robbery second that goes along with that. The seriousness of the offense. She is charged as a habitual fourth offender, which makes it the 4-year felony up to a 15-year felony. Probability of conviction and likely sentence isn't going to be scored to her yet.
No, Your Honor, I
No,
Employment, financial status, and history. I've not heard anything regarding that. Responsible members of the community who would vouch or monitor for her. Ties to the community, relationships, length of residence, and any other factors regarding risk, appearance, and danger to the public. I'll admit what the court knows on this case is limited exclusion.